being here. Thank you for submitting testimony. So I did talk with the director of the state hospital, and their concern was determining whether somebody is fit to testify and whether someone was, what their mental state was in the event of the incident should be separate, because sometimes whether or not they're fit to testify may be days, months after the actual event, and may need to be separated out so that you don't have to know as much of the background of the case, so that you can just determine, yes, they're fit today to testify, and not have to involve all the other matters that happen at the event of the incident.
Thank you, Representative. If I might, the two components again are fitness to proceed. It's not just testify, but it's fitness to proceed and criminal responsibility. And the fitness to proceed is determined at that moment. It's fitness to proceed to enter a plea. Does the person know what's involved in entering a plea? Do they? It's fitness to proceed to work with their attorney. So it's at that moment, and it obviously changes over time.
Yes.
The criminal responsibility, or what we use in our statute, penal responsibility, is the mental status capacity to conform behavior to norms and withstand impulses at the time of the offense, and only at that time. So the one is a historical review, and there are evaluative challenges to figuring out 6 months or a year later what was the mental status and capacity to conform behavior at the time of the offense. But in some ways, since if the person's going to trial or going to have a hearing, the fitness issue is just that day. It's the day in which that hearing is happening, and because of the nature of some mental health challenges and others, they can wax and wane. They can be fit one day, not fit the next, but it's assessed right then.
I understand. My question was because there's conflicting. So some say, I guess, some of the people in support as well as the state hospital, that it's going to expedite the procedures, but in the other testimonies, it might be lengthened out according to perhaps the court. So is it going to expedite? Can I have Judge Browning's representative speak to that?
Thank you, Representative. Let me first start by saying that I am assigned to the family court, and we had concerns with respect to this bill and the release of information regarding juvenile court.
Yes.
So the judiciary sent me, and you get me. Nonetheless, on behalf of district court, the concerns that the judiciary has with respect to bifurcating the examinations for fitness and penal responsibility mainly focus on misdemeanors and petty misdemeanors. And in district court, what happens is, if a defendant is found to be fit, they can proceed to trial as to penal responsibility, or if there's not an issue as to penal responsibility, they can proceed to trial as to the merits of the case almost immediately.
I see.
And so this two-step process, in the judiciary's view, would unnecessarily lengthen the detention for defendants who are charged with misdemeanors and petty misdemeanors. And keep in mind that someone who is charged with a petty misdemeanor, the maximum possible penalty under the law is 30 days in jail. And so if this process doesn't wrap up within 30 days, they've already been then incarcerated or held in custody longer than the maximum possible penalty. And we see that happen from time to time. And so from the district court standpoint, and that's why our amendment is we're asking that this two-step process only happen for defendants charged with felonies, because on the felony level at circuit court, if someone is found fit to proceed, there is a length of time necessarily before their trial gets set, okay? But in district court, the trial happens almost immediately. For example, if someone who is being arraigned in district court this morning in courtroom 7C, if they're held in custody, they have a right to their trial within 48 hours. So by Friday morning, they have a right to have a trial. That's the common practice in district court. So district court misdemeanor and petty misdemeanor trials happen almost immediately. And this two-step process, in the judiciary's view, for those levels of crimes, would simply take too long and run the risk of having defendants overstay the maximum incarceration period.
Which we're already having an overcrowding problem. So, understood. My other question was in regards to releasing of records, because I read through your testimony. So, fitness to proceed, penal responsibility, would the releasing of records the second time, since if you do separate it, cause a problem not only for juveniles, but in general, because you'd have to release information that was historical at the time and then has to come back forth again for fitness to proceed?
I think our concerns would be as to the releasing of the records at all, and at any point in the process.
I see.
The promise that our statutory scheme, 571-84 in particular, has made to all juveniles in juvenile court is that the records relating to juvenile court will be held strictly confidential. And juveniles in the court systems and their families have historically made decisions based upon the promise that those records would be held confidential. And so any proposal that would allow for the release of those records, particularly in electronic format, in our view, causes us great concern.
I see. So last question for the prosecutor. So lengthening of time due to separating it for petty misdemeanors, misdemeanors, as well as release of records for juveniles. Other than those two, you guys also have additional concerns, or those are basically the same?
I think it is a concern. I think we all shared it. The amount of time it would take to do the fitness and the medical exam takes longer than they can be held in custody. So I do agree with the petty misdemeanor and misdemeanors. Our concern is more with the felony offenses. As our testimony indicated, the Class Bs and Class Cs, I know the charges that are not info charging, that could include robbery, sex assaults. So it's more so in determining the felony offenses that we're mainly concerned with.
Okay. Thank you. Thank you, Chair. Thank
other
you,
questions?
gentlemen.